arbitral tribunal. Apart from the above, we also note that the impugned award does not rest on the question of impugned award also notes the subject land has good potential. Further, it is not disputed that the subject land, at the material time, the subject land was reflected as a residential land in the revenue. It is not disputed that revenue record did not reflect the subject land as agricultural land by virtue of the by virtue of the conversion order dated 5/9/2012.
Towards development, they have not deducted any land, that
although
is.
Although the NHA now seeks to contends that although the Learned Counsel for NHS contends that the conversion order is lapsed, there is no material to indicate that the conversion order is subject matter of any challenge at any stage. There was also no occasion for the courts to examine whether the conversion order was in subsistence, and if it had lapsed, whether it was capable of revival. It is right law that the scope of interference in the arbitral awards is limited, and an arbitral award cannot be impeached except on the grounds as set out in Section 34 of the ANC Act. In the present case, the appellant seeks, NHI seeks to assail the arbitral award, impugned award on the ground that is vitiated by patent illegality. Illegally, full stop. However, it is well settled that the ground of patent illegality would not cover would not include cases where how it's well settled that the ground of patent illegality would be applicable only where illegality strikes at the root of the award. A plausible view would not fall within the scope of challenge on the ground of patent illegality. In the present case, we are unable to accept that the impugned award is vitiated on the said ground. The arbitral tribunal has enhanced the compensation on cogent grounds, and the award cannot be stated to be perverse or one that offends, cannot be said perverse, or one that no reasonable person or accepting a view that no reasonable person would. The present appeal is unmerited and accordingly dismissed.
There should be some deduction, as for the conversion argument.
We are not here. We are not. You run.
State exchequer will be burdened.
That's for the state exchequer to find out.
Undeveloped land.
We are not here calculating your compensation. That's for the arbitral tribunal to do. You pleaded, you set out a case, and it was completely ignored, you would have interfered. No ground to interfere in this at this stage in 37.
Writ appeals, SL number 70.
But the difficulty,
Based on dash before bench of which one of us. That's a jail. Packet closed, not a thing.
is
28th January. SL number 18.
Notice was challenged before this court in the first instance on the ground that the reserve price was not fixed, and my request for effecting private sale was not considered by this court. I mean, the competent authority. This on court, my lord, disposed of the writ petition, they said writ petition, page number 37, my lord. The operative portion is at 38, my lord. The respondent 5 bank shall indicate the approximate market value in any subsequent action sale notice of the property in accordance with the rules. Liberty is reserved to the petitioner to make a request to the respondent 5 for making a private sale with details of said sale transaction, price, etc. And if such a request is made, the respondent 5 shall appropriately consider the same and take a decision there with appropriate conditions as it may deem fit. So I have alleged collusion between the prospective buyers and the authority which brought the property for sale. Lord. In that context, the writ petition was filed. Lord, thereafter, Lord, I have made a representation at page number 40, Lord, immediately after the disposal of the writ petition. They have responded to this request saying that though I have indicated the buyer, you have not quoted the sale price at page number 15, Lord. Even before responding to this the communication, my lord, they have proceeded to hold the action sale again, and the sale certificate was issued, which was challenged before the learned single judge.
The order indicates that you challenge an endorsement of 23/2024.
Yes, ma'am.
The learned single judge has found that there is an alternate remedy.
By then, Rule 38 could not have been invoked, ma'am. There was no proceedings pending. The sale had already taken place and the sale certificate was issued. I could not have made invokes of Rule 38, ma'am, which provides for attachment and sale of the property. All the grievances I put forth before this court was not, there was a collusion between the
See the endorsement.
endorsement, ma'am,
Into
at page 154, ma'am.
one.
154. Subject regarding due to the non-payment of the mortgage loan of so and so. In relation to the matter, it's Shoga wife of so and so. We have taken a land mortgage loan from Shimoga City branch, and we have not delinquent by not repaying the loan on time. So legal action was taken as per reference number 1. As per reference number 2, it is here informed that an open action process was organized on 23/22/4, and total 3 bidders participated in the open action held on the said day, and Mr. Supriya S., daughter of the Shiva Prakash, Rup Prakash, so and so, was declared as the successful bidder for the highest bid of amount of 42 lakhs 10,000. In fact, I had a prospective buyer.
Has a sales certificate been issued?
Yes, ma'am.
Issued.
I take notice for respondent number 1, my lord.
Let the prospective buyer action purchaser, let him not create third party interest, madam.
Let them notice. Merit. Council for one exception, notice will go to others.
So 8th of April. Seal number 19.
This is the cinema matter, my lord.
Yes.
This is cinema matter.
That's right. The
26.
Court now is single.
Correct. All the other matters are coming up on the 26th of February, my lord. It may be tagged with that.
26.
Based on 26.
It may be tagged with writ appeal 1623 of 25.
Along with writ appeal
1623 of 25.
1623 of 2025.
Seal number 20.
Okay. 20. The second process.
Place the pleadings on record.
Yes.
Last state of hearing, lordships we placed the 3 statement of claims. One statement of claim was placed before lordships. Lordships are directors to place the other 2 statement of claims.
Only for the filing. We had heard you on this.
Yes, madam.
No further hearing required.
Only one.
Have you in the pleadings are the same?
Similar. Pleadings are similar
In all of the cases.
in all this.
In 183, this franchise agreement of 2016 is pleaded.
Yes?
In CM ComAP 183,
Yes.
there are 3 cases, madam.
Yes, 183, 184, 185.
In 183, this 2018 agreement is pleaded. Franchise agreement is pleaded. Your Lordship may kindly see the order in CMP, my lord. Lordship may kindly take the order in CMP, my lord, in 183.
No, your case was novation. We wanted
Brother.
to see where is the novation.
No, that is not the case. I did not say.
No, you are saying it's an error on the part of
Arbitrator
the
to,
arbitrator to have mentioned novation. There is no plea of novation.
there is no plea of, and my lord, this plea of novation initially was taken by the other side in the CMP petition itself. You will ask me kindly see the CMP order for amendment in 184, my lord, page, they have produced the documents today. In that, you will ask me kindly take page number 99 in 184. There is a CMP order. This is a common order for all cases. In the document set produced on the last date of hearing, CMP order, this is common for all the 3 orders. (184) In that, my lord, the copies furnished by the other side. 96 is the CMP order. Last time I kindly come to 99, page para number 4, where this clause is extracted, and you last may kindly come to para number 4. Notice having been ordered, the respondent has entered appearance and filed a statement of objection contending that the agreement relied upon by the petitioner is superseded by another agreement dated 31/12/2018. On inquiry whether there is any material difference from the earlier agreement produced by the petitioner, learned counsel for the respondent fairly submits that there is no such difference as regards the arbitration clause, but however submits that as regards the other clauses, there may be slight differences. The arbitration clause in the agreement produced by the respondent dated so and so at article number 6 reads as under. That has been extracted. In view of the above, that an arbitrator could be appointed to arbitrate the dispute in terms of the agreement produced by the respondent, leaving all contentions open. Hence, I pass the following. But at the stage of appointment, court has not come to the definite conclusion which agreement is in operation. Court has left it because in the
No. It is your case that this is the agreement in operation.
yes, madam.
That the operative agreement is 31/12/2000.
No. I said 6/12/2018. They said 31/12/2018. And before the arbitrator, my lord, for both these 6/12/2018 agreement as well as for 31/12/2000 agreement, objection is taken by the other side, not by me. But my submission is, at the time of appointment of arbitrator, if the question is not decided, it is open for the arbitrator to decide which of the
Arbitrator can only decide
on the
whether
basis.
that particular agreement is
Yes.
acceptable.
Yes, my lord. No. Here,
Can decide another agreement.
my lord, no, in that, my lord, this 6/12/2018 agreement, 31/12/2000 agreement were preceded by 29/2/2016 agreement. This 6/12 is not a first, it has come into existence for the first time. This is preceded by 19. If both the agreements are to be said legally invalid, then my contention was that first agreement will hold the field was the ground urged by me before the arbitrator. But in the arbitral award, the arbitrator says that I cannot plead this ground of no novation because I have signed it. But my lord, he has also recorded the objections of the other side for these two agreements, which says that 6/12/2000 agreement, 18 agreement is not stand, and 31/12/2018 agreement describes the claimant as a sole proprietary firm, but it is in fact it is an unregistered partnership firm. And to overcome this, I have taken this objection. They have recorded, but the arbitral tribunal has not supplied any reason, in spite of having these legal objections raised by the other side, why it is to be, how this is applicable or how this legal infirmity raised by the other side is overcome. It is not forthcoming from the arbitral award. It only says I cannot raise. But what about the objections raised by the other side? How it is answered? It is not nowhere answered.
Arguments were covered.
May I kindly clarify? Right.
Still number 21. So, Subramanya.
Pass over, we'll pass over.
Please.
This is number 22.
Now this is- Now this is infructuous, no? What relief do you want? What relief do you want?
In this case, my lord, the total election itself, we have challenged, my lord, the rule 13D was not at all followed by the society
No, what is your,
while
what,
conducting the elections. my lord.
what is your prayer in
case
the,
is that
what is
madam-
your prayer?
I have filed several applications before the society, my lord, the sixth respondent for providing all the records for conducting the elections for the candidates of the list and bylaws of the society, my lord. That
No,
was not
there's-
produced and
Your entire case was there was a notification by which elections could not be held.
my lord, that is also one of the ground.
Which
But
is the
main
other?
ground is that, my lord, the rule 13D was not followed by them while conducting the election because the list of candidates, my lord, the
Let's see,
rejection
where-
of the
where-
list of candidates and
Where
bylaws.
have you said this?
I have said everywhere in my petition, my lord, in page number, my lord.
Well, let's see. Your what?
My lord, in page number 57, my lord. My petition, my lord. Para 16. And a whole pleading itself is that, my lord, the election was not properly conducted by them. In para, my lord, the petitioner submits that, may I read, my lord, the particular para? Without following the procedure, the sixth respond by violating the rules and regulations of the act and without following the terms and conditions of the bylaws of the society, the sixth respond arbitrarily by using the political influence and unanimously elected the president and directors of the society. In fact, the date of
So what do
election
you-
was not announced in the daily news.
What can you understand about Rule 13 here?
Rule
He has
13
not
was-
followed it, he has done political influence, something. Where is that?
Rule 13 was that, my lord,
Where have you mentioned it?
My lord-
The learned single doesn't refer to Rule 13. That's why we are asking you, how have you
yes,
articulated
Rule
your...
13 was not at all, my lord, that aspect was not taken by the learned single judge.
No,
while
no, that
disposing.
aspect is not taken by you.
I have-
Therefore, we are asking you, where have you taken that aspect before you fault the learned single judge for not considering it? You tell us where have you taken it?
My lord, I have raised that, my lord, kindly see, my lord, in page number, my lord. It is my petition, my lord, wherein
That's right, we are reading your petition only.
Lord, on page number 55 only, my lord, para 11.
Yes.
The sixth section has total suppress the information sought by the petition by using their influence and politicals. The utter shock of the display of the petition is that on 23/2, after seeing the news published in the Kannada Prabha newspaper about the election conducted by the sixth respondent and once we
We are asking you something else, you are reading something else. Where have you said this election violates Rule 12B?
violation of 13B.
Where?
Indeed.
13E, whatever. 13E.
My lord, in para 9 also, my lord, I have stated that it is, he has filed an application on 31/1 under RTA to the third respondent requesting to provide the proceeding sheet of the general body meeting in connection with the election for the year 2022-23 of the sixth, but the respondent has not given direction to the sixth respondent And wherein, my lord, once again I have stated, my lord,
You understood what we are asking you. Your argument is that it violates so and so. We are asking you, where is it said? And if it is not said and the learned single judge has not considered it, obviously can't allow you to take it up.
rule was not specifically mentioned, but my lord, it is pleading. I have mentioned that, my lord, they have not given provided any list of candidates, whatever we have asked for the documents, my lord.
So your argument essentially is that the elections were postponed and therefore how is the election held? And that the learned single judge is dealt with. That decision, if you want to halt it, you tell us, otherwise.
But none of the documents which you have sought for has not been produced before conducting the election. Before the entire election which we have sought for, my lord, cancel the election, my lord.
We find no ground to interfere with the impugned order. The same. The appeal is accordingly dismissed.
Lord, I may be permitted to file the election petition before the appropriate forum, my lord.
You want to withdraw it with liberty, we'll give it to you.
Your Chief, that may not be possible because for the federation, individuals cannot be members. He's come as an individual.
This order will not preclude him. Merits he can, we are not deciding.
Lord, I may be permitted to withdraw this appeal and.
Are there some arguments? Learned counsel appearing for the appellant seeks to withdraw the present appeal. The other seeks to reserve the right to challenge the impugned election before by filing an election petition. The appeal is dismissed as withdrawn. We clarify that this order will not preclude the petitioner, appellant from filing an election petition. Needless to state that if any such petition is filed, this same would be considered on its own merit. The same would be considered on its own. The question of maintainability and merits of the said petition would be considered. This order cannot be precluded from. It could not be construed as an expression of opinion that any such petition is either maintainable or would warrant any interference by the concerned court.
Number 23.
May please, Your Lordship.
Permitted to appear for the state, my lords. My lords, in this writ petition, my lords.
May please, Your Lordship. The writ petition was.
My lords, before the learned counsel for the petitioner starts, my lords, there was a direction by my lords to have a meeting with the Karnataka State Legal Services Authority with all the stakeholders, my lords. Now the Legal Services Authority has placed on record the report of all the 3 meetings which were held. My lords, I just want to bring it to the notice of my lords, the Karnataka Prohibition of Beggary Act. What is beggary says, my lords had directed us to give a report on what is the, my lords, mainly the prayer before my lords is child beggary. I just want to point out this, my lords, then I'll point out about the report. My lords may kindly look into the definition of beggary.
Let me make my.
I'll just finish this, my lords, then Learned Senior Counsel can answer. My lords, I'm placing on record the Act, my lords, the Karnataka Prohibition of Beggary Act 1975. If my lords will turn to the definition clause, section 2, my lords, section 2, clause 2 defines about beggar. My lords, beggar means any person other than a child. My lords may kindly mark it. Child who solicits or receives alms, explanation is there, my lords. Now, my lords, section 2 clause, section 4 defines what's a child in the same. Child means a boy who has not attained the age of 16 years or a girl who has not attained the age of 18 years. Now, my lords may kindly turn to section 31, which speaks of beggary cess. Section 31 of the Act, my lords. My lords, Beggary says, with effect from such date as the government may by notification appoint a Beggary cess in the form of a surcharge on tax on lands and buildings, tax on entry of goods into local area for consumption, use or sale therein, tax on vehicles, tax on professions, trades, callings and employments, and how it has to be collected. Now, my lords, I would like to place the affidavit of the Women and Child Welfare before my lords.
No. How is this Beggary says to be used?
Please, that's also available. If my lord sees section 32.
Yes.
Before that, my lords. Central Relief Fund, my lords, is there is Central Relief Committee 13, my lords. 30, sorry. Central Relief Committee, my lords. In order to carry out the purposes of this act, a fund called Central Relief Fund shall be formed. The fund shall consist of subscription and donations, grants from the government, the cess paid under subsection 3 of section 31. That is the Beggary cess, my lords. My only endeavor before my lords is Beggary cess, my lords, is utilized for beggars which is defined under the act. And for the child, my lords, this is the procedure, my lords. I may place this on record. My lords, this is from the Women and Child Welfare. We got a status report, my lords. As there are many stakeholders, my lords, different affidavits are being placed before my lords for consideration.
See, there is Beggary says is
Please.
collected for the purpose of the act.
Please.
Therefore, it can't be used elsewhere.
We are using it only for the under the child, my lords, the relief committee.
No,
It is
even if you don't use it for a child, and if you otherwise want to eliminate beggary,
please.
So long as it is used for that purpose, all right.
Please.
That's what we want to know. How is it being used? It's collected. How is it being used?
Please. For that, my lords, we have placed on record an affidavit of Child Relief Committee also, my lords. It's available. I may just. Right now, the affidavit which I passed on, my lords, is from the Women and Child Welfare pertaining for the child, my lords. This is the status memo.
My Lord, on behalf of the Legal Services Authority,
And for the Child Relief Committee also an affidavit is placed, my lords, how the, Central Relief Committee, how the Beggary cess is used also are placed on record, my lords.
So this affidavit
That is
which was-
A.B. Vijay Kumar, this is another affidavit.
That's right. So if you look at it, local authority, collection of Beggary cess is 0, accepted by the Central Relief Committee 3374.
yes.
What does this mean?
My Lord, if my Lords could see the final report filed by the Legal Service Authority, we have in fact looked at this information that had been provided in respect of the Department for Panchayati Raj, the amount of cess that has been collected, the amount of cess that has been deposited, and the amount of cess yet to be deposited. That is there in our report, my lords. Similarly, for the Directorate of Municipal Administration, the amount of cess that has been collected, amount that is remaining. If my lords could just see the report of the Legal Services Authority, dated 14th January 2026.
This 14 January.
Please. At page 12, this data had been sought for from the government as per the orders of this court. Page 12, para 26. On verification of the entire statistical information submitted by the RDPR and Municipal Administration, what is the Beggary cess collected, remitted to Central Relief Committee and due as on 31/10/2025 is tabulated as below. Insofar as RDPR is concerned, the balance Beggary cess amount to be remitted was shown as rupees 34 crores 43 lakhs. And my lord, in respect of municipal administration, the balance was shown as 4 crores 88 lakhs. My lords, in this regard, there is actually a discrepancy insofar as the data in regard to the Panchayati Raj department is concerned, which we have specifically laid out. My lord would see paragraph 28 of my report. Paragraph 28, it is seen from the above that the statement placed by RDPR department as per Annexure G and M do not tally with each other. As per their own statement placed at Annexure G, this was the first meeting which they had given. The amount due is rupees 72 crores 82 lakhs 39,649 for remittance to Central Relief Committee. However, as per the statement at Annexure M, the amount due is rupees 34 lakhs 43 lakhs 16,535 for remittance to Central Relief Committee as on 24/12/2025. There is no clarification explanation from the RDPR with regard to the difference of amount collected, remittance and due as per the statements as at Annexure G and M. We had in fact written to them also, because initially they said that the amount due was 72 crores and subsequently they said that it was 34 crores. That balance amount whether they had deposited in this intervening period of 2 months is something that they had not placed on record. Insofar as the municipal administration is concerned, it's at paragraph 29, the amount information. But the information that we have received from the Central Relief Commission is that for the year 2024-25,
Your file shows that this is the affidavit that was being referred to by this Mr. Vijay Kumar.
That's from the Central Relief Committee, my lords.
Yes, if you look at page 6, information received by the Central Relief Committee. TNP collection of Beggary cess information provided to Khalsa is 0.
Yes.
But what
the remarks may just be seen.
more has been noted for the year 24-25.
Please, this is what we have received from the Central Relief Committee. But BBMP has not furnished any information towards this.
Is anybody appearing for BBMP?
May I clarify the questions?
Yes.
This writ petition was filed with a limited prayer that the children are deprived of the education. Your Lordship, kindly see the prayer in the writ petition.
Yes, sir.
That's the only prayer, my lord. Nothing to do with the Beggary cess or anything. Then, my lord, the state, neither the state nor the BBMP filed any objections. They did not even appear before this honorable court when the matters were called. Then this honorable court sought the assistance of the Karnataka Legal Services Authorities and directed them to file a report. Then, my lord, when the report was filed, certain shocking informations were revealed by the KSLSA, my lord. All these things are referred to, my lord, in the order dated 23/4/2021. They have gone in detail. One of the shocking things, my lord, that was noticed is the children, my lord, aged in the age group of around 6 to 7 years, they are trafficked, you know, they are used for sex and all those things. That is a report given by the Legal Services Authority, not by us, Miller. In the light of that, then at that stage, Miller, this honorable court also clarified that the Beggary Act should not be utilized for coming in the way of these persons, and it is independent procedure because that depended upon an order passed by His Lordship Justice Keher and another Miller, as it then was Miller. The order was passed, that is annexure A in the writ petition, wherein it was pointed out that the cess, suppose we pay a property tax of 30,000 rupees. 3% of it is collected as cess, Then out of that 3%, 10% is utilized by the administration charges by the corporation. The balance amount has to be paid. What was noticed by this honorable court was entire amount was utilized by the corporation itself. No amount was paid to the collected under the Beggary cess was given to the Central Relief Committee. It is for that reason they were not in a position to render proper justice. All these things are discussed in the order dated 23/4/2021, Miller. Then Miller just come to light, Miller. Several lakhs of rupees are due to be paid by the corporation to the Beggary cess, Miller.
That's
So,
what we like. That's what
yes, Miller. So those details are called now, Miller. Both the government has filed their report as well as the Karnataka Legal Services Authority. Vast difference is there between the two reports.
Yeah.
The Legal Services Authority, Miller, in the latest report that is given on 14/1/2026, all these things have been noticed, and then they have concluded that
even the Central
Relief Committee.
Central Relief Committee. Central Relief
the
Committee.
BBMP and the Panchayat will be with the government.
Yes.
My lords, on behalf of my lords, I am appearing for the state.
You are appearing
Yes,
for the
please.
state.
Yes.
So if you are appearing for the state,
Yes.
then as far as the funds are concerned, you have to collect them from.
My lords,
Panchayat
the funds are collected both from the rural local bodies and urban local bodies. From 2021, my lords, there is an escrow account created. As soon as the monies are deposited by way of tax, my lords, the Beggary cess is separately collected over there, and then it is sent to the Central Relief Committee. My lords, the earlier ones which are due, my lords, that is what is placed before, my lords. And the latest report of KSLA, my lords, where they say discrepancy. We have sought for instructions from the RDPR. What is the discrepancy and what is the amount which is due? That I'll place on record, my lords. What is the amount due? But as far as the urban local bodies are concerned, my lords, what is placed is even KSLA says it is accurate. Whatever we have collected, it's already gone there. The others which has not yet come is not yet gone to the Central Relief Fund. So we have written, my lords, we have placed on record 2 affidavits, one of RDPR and one of the Director of Municipal Administration, my lords. 2 affidavits are on record, which explains, my lords, what is the amount. My lords, in fact, from the last date of hearing till this date, my lords, we have placed on record almost, we have collected more than 30-40 lakhs, my lords, in the span of 3 months by writing letters and communicating. They are depositing, my lords. It's an ongoing process. We are at it, my lords. That's what that's.
But if you look at it, your collection is 70 crores, deposit is 30 crores.
Lot of difference.
My lords, may kindly see the
affidavit only page 6.
Please, my lords, the affidavit of the Director of Municipal Administration, my lords. If my lord sees para 6, my lords, I have explained.
Which municipal administration?
For the urban local bodies, my lords, one affidavit by the Director Ravindra PN, if my lords will get it. On 17/1/26, an affidavit is.
What does it say? Tell us.
My lords, para 6, my lords. I further submit as on 31/10/25, para 6 I'm reading, my lord. As on 31/10/25, the remittance of balance amount of 4,220 lakhs. I further submit this directorate has issued written directions to all urban local bodies to ensure timely remittance of the entire balance amount of Beggary cess in accordance with the applicable rules and the government instructions. My lords, next paragraph. I respectfully submit that as on 13/1/2026, an amount of rupees 3,612.93 lakhs remains pending to be remitted. The consolidated details indicating the pending remittance are placed on record. I respectfully bring to the notice of this honorable court a separate escrow account has been created as on 29/3/21 at the level of urban local bodies exclusively for the purpose of depositing the cess component of Beggary cess. I respectfully submit that the amounts collected towards Beggary cess are credited to the said escrow account and thereafter remitted directly to the concerned departments in accordance with the applicable government instructions, thereby ensuring financial discipline, traceability, and purpose-specific utilization. My lords.
What about BBMP? This at least will cover that. What about BBMP?
BBMP, they have a council. They have a panel council.
In fact, they had attended the meetings that were called for by the legal service. But then,
Some elaborate to it.
please.
Apart from this, you also
One other aspect,
we'll also have
Please. Lord, in fact, along with this final report, I have placed.
the funding.
Lord, I have filed a final report that was submitted by the KSLSA on the larger issues of concerning children. In that regard, my lords, that is part of this. I have also placed it as an annexure here, which looks at the different categories of children, what needs to be done for each of them in order to ensure that they don't fall into this. Those, if my lords could see that, and some directions could be passed on that.
Issue, one other issue, that requires my lord's direction, is they have brought to the court's notice, that there are several criminal cases, that have been filed regarding trafficking. What is the stages of those cases? The court had directed them to get that, they have not been given.
No, the affidavit is ready, my lords, of the Bangalore City Corporation Commission.
I'm mainly concerned with those children in that sense.
No, what we anyway propose to do is, in any case, it will be run through KSLS. They'll run it as far monitoring. The court may not be able to monitor it, but
Your Lordship.
In fact, my lords, the 3 meetings were.
Can keep it. So we'll keep this any case as petition alive.
Yes.
Not be closed, as in when the orders are required by case.
Please.
Can be monitored. Great.
2:30 minutes.
Still number 24.
For an adjournment with the consent of my learned friend, my lord, because I intend to file an additional statement of objections, my lord. If my lord could grant me 2 weeks' time, my lord, I'm not.
A week's time may kindly be granted for them to file any rejoinder.
Sir, I'll do it before that, but give me 2, I'll do it.
Please, my lords.
They need AGS 6 for the time. 6 time to file additional statement of objections. Let the same be filed in the period of 2 weeks from date list.
Obliged, my lord.
9th of February.
Please, my lord.
Still number 25.
Lords, I appear for the petitioner, my lords. Lords, I'm challenging the endorsement issued by the Department of Mines and Minerals, my lords.
My lord, in this, there is a subsequent event, my lord, on 4/11/2025. My lord, they have auctioned the iron ore that was, my lord, stocked in the petitioner's premises, yes, and my lord, it has been, the highest bidder has quoted 6 crores 77 lakhs, my lord, which has been accepted.
Your remedy, you were out of 7 crore 63 is the base price.
My lord, I just got this today.
Lords, there was a direction from the Honorable Supreme Court, my lords. The direction is at page 72, my lords. 73, my lords. The respondents were directed to conduct an inquiry before issuing the endorsement, my lords. Without,
They've issued an endorsement by saying, inquiry by saying this mining is not from this area.
sorry, my lord.
They have said this ore is not from this area.
But the direction from the Supreme Court is to conduct an inquiry by the department, my lords.
They've done an inquiry.
They haven't done the inquiry, my lords. The endorsement, my lords, can we have a look at the endorsement, my lords? My lords, it's at page 29, my lords.
Yes.
My lords, last para, my lords. My lords, the representation submitted by you with reference to has been examined. As per the said representation and as per the report submitted by the senior geologist Beggary, dated 21/6/2023, it is concluded that the iron ore extracted and stored is not in accordance with the MMDR Act 1957. Further, upon verification of the office records, it is observed that the above said mineral is not extracted from the mining lease area granted under the MMDR Act 1957. My lords, it was not stored or it was never in my custody, my lords. My lords, the crux of the matter is this, my lords.
According to you, when you were leveling your agricultural land, this ore came up.
Please, my lords.
25,000 tons came up.
Please, my lords.
My lord, unless it
Thereafter, I
is
was acquitted of all the offences, my lords. Thereafter, I made an application before the learned judge, my lords. The judge allowed the application, my lords, and directed the forest official to hand over the custody of the minerals, my lords. That was challenged by the Honorable High Court.
As far as the criminal proceedings are concerned, the seizure will have to go back to the person from which they've seized after you find out, after inquiry. So therefore, it came back to you. But where is the ownership? How are you owner of this mineral? You have no mining lease.
My lords, I do not have any mining license.
You don't have any mining license. You don't have any mining lease. You don't have. Your ore is lying there. Obviously, what other option is available? You can't take away the mining. The ore which is beneath the surface. What? We're not able to understand. What right do you have to this ore?
I am only asking to declare me as the owner of the property material that was seized in my land, my lords.
How are you the owner of the property? That's what we are asking you. How are you the owner of ore?
Lords, that was found in my land, my lords.
Anything that is found on your land, you become the owner. You have only surface rights. You don't have the mineral rights.
Lords, but I have the provision to seek an application before the state government to transfer.
Please, I have now this ore should be. I have mined this ore illegally, but I should get the fruits of this also.
I request for an adjournment, my lords. My lords, any day next week, my lords.
You have to first
I will
establish on your admitted facts.
Please, my lords, I will convince
your
my lords.
admitted facts, you have no mining lies. Yet your ore is lying there. According to you, you don't know from where the ore came. It was just you were leveling agricultural land and therefore ore popped out.
Please, my
of the land.
Lords, can you have it next week, my lords? I will convince my lords.
What a very uphill task. You request wise one more.
That's okay. It will be giving
for the petitioner. He seeks to. He has a right to evaluate the ore.
For a date, my lords.
12th of February. Number 26.
We have filed IA 9/25, my lords. In this matter, the lordship's order dated 2011-2025 had permitted with insofar as the existing notification is concerned, my lords, in terms of the Supreme Court order. We have filed this IA 9, my lords. We have 54,000 vacancies, my lords. To go ahead with
now. Finish off 54,000. We finish this match. Put every recruitment on freeze. We have only stated you can continue recruitment on the notification as it stands. It means you don't get 3% extra reservation. You can find your
7%. 7%.
3%. Please. So you don't want to recruit persons except without reservation.
No, that's not. I anticipated what similar issues are identical subsequent to that last time's order. One more order is Supreme Court.
Can I just point out your logic?
No, I got enough difficulty already.
Yeah, the matter of merit.
Your Lordship, just one. I understand your Lordship. Your Lordship, just subsequent the order of the Supreme Court. Only to point out to limited the matter listed for final hearing in Supreme Court in January 2026 was the last order passed. In the very same Chhattisgarh, where petition from Madhya Pradesh has been transferred to Supreme Court to hear the same issue. With regard to increase, because the Madhya Pradesh, the state government, an application was filed by the Supreme Court to transfer the petition from the High Court to the next order. That is the order dated 4th December 2025. Order dated 24th September, we have made it clear at the outset that we will hear the matters pertaining to state of Madhya Pradesh first, and we will take up the matters pertaining to state of Chhattisgarh on a later date. We direct the registry to list the civil appeal, writ petition, transfer cases, transfer petition relating to state of Madhya Pradesh, list the matter of state of Madhya Pradesh in the final hearing list before the appropriate bench in the month of that is Madhya Pradesh. This is the turn. This is the correct. That your Lordship will get it, if I may request in the same order copy, order sheet that is at page number 3 of 10, those repetitions before 3 of 10 page number, the order sheet, WPU 97 of 23, 122 of 23, which are pending before the Madhya Pradesh High Court, it got transferred to the Supreme Court. So therefore, the identical issue is pending, which is going to be heard immediately, probably just said January. My only request is pending that ultimately the connected, they are not going to be effective. Ultimately, is if at all, assuming it is Supreme Court says it cannot go above 50% or 56%.
There is a consultation process which there is substantial ground. That's why we have passed the order. And now you can, as far as the pending notifications are, that you can do so. As far as your future notifications are concerned, you please proceed with the notification as it already stands. If today your recruitment with reservation of 50% is not indicated,
that is not.
Now you are going like you only want to have some extra reservation or no recruitment at all. That's your choice.
The only thing is I'll continue with this.
No question of recruitment. Except by 7%.
No, ultimately, if it is such, I'm saying in the worst, if it is such, the 6% can be adjusted for the future year. This year, ultimately it may come down as to that we have recruited 6% extra. Insofar as that can be worked out at a later point of time.
If you look at your other decisions, Subara this carry forward has been a next issue. Because some other generation which is coming will then get it. That's not a happy situation. So you can continue with your recruitment, include your notification.
Or in the alternative, I'm just trying to let permit us to go ahead. So far, 6% will not give any appointment till your Lordship decides the matter. Let us go ahead. Permit us to go ahead with the selection process. Appointment orders so far as this 6.
It's not only them. What about
no, actually, this cannot. You will not give appointment.
Give us the affidavit what you
Well, with respect to subject,
do it and proceed with
with respect to subject, the learned AG is referring to an order of 2028 by Supreme Court, whereas two subsequent orders Supreme Court, my lord, in 29/7/94 in Bihar and in 4/7/25 Supreme Court refused to stay an order which they wanted go beyond 50%. That is the position of the interim order before Supreme Court. So also the final order.
What is now being suggested is that if any future notification, no appointment letter will be issued.
That should not be allowed because having regard to latest position, legal position, either on interim order or final order, Supreme Court says don't beyond. They are saying we will go beyond 50%, but later correct and we try to correct it by further treatment. In other words, it is an attempt to make illegal appointment. Thereafter correct it.
There will be no appointment. There will be no appointment on the additional reservation. That order is interim. Yeah. That we are not permitting. And they are also, but they have to make some recruitment.
Can I make the submission? I understand what you're talking about. In the process of recruitment, the ratio would begin right after the preliminary examination. So the ratio, after a person writes, the number of candidates who go through the further selection process is in terms of the reservation that is provided.
Let's say recruitment wise, it may not be preliminary itself.
Yes.
There may be some cases where there will be a straight recruitment.
Even in terms of Viva, after Viva for document verification, the ratio that is applied is in terms of the reservation. So whether even if appointments are stalled and ultimately the reservation is changed, then the entire recruitment will have to be redone. Even otherwise, can I just put forth this? After having appeared for both selectees and those who challenge selection, the moment a list is announced, people will have to give up other recruitments or other jobs and furnish documents here. Third party rights will be
interim order.
Yes.
And in your interim arrangement, one of the aspects that we also required to look into is that what will be the position if you go ahead with the past notification.
Yes.
That means some reservations which ought to have been there are not there.
Yes. Therefore, my submission would be twofold. One, in the 2711 para 6, your lordship specifically said no further recruitment. That order stands till today. Now, by a further IA, the portion of para 6 of your lordship's order of 2711 is sought to be diluted. Para 6 of the order dated 2711. 2711 para 6. Considering that recruitment process has already begun pursuant to the certain notification specifying the enhanced reservation under the so-and-so, we consider it apposite to modify our order dated 1911 to direct that no further notification for recruitment or appointment on the basis of increased reservation would be issued till disposal of the present recruitment. This order stands today not modified, not sought for review, not challenged. By way of a further IA, this is sought to be modified. My respectful submission, even on the last report, to the extent that 50% reservation is permissible, recruitments go on. The only disputed portion would be 6-7%, for which vacancies will remain. And after your lordship to decide, to those posts it can be.
We will finish the recruitment. We will not issue appointment order. Ultimately,
what is saying is something else. The vacancies that you will, for which you will issue the notification, will be sans 6. Or your 7%, you remove, put a 7% aside and issue notifications for the balance on the reservation that you have.
Please.
And you continue your recruitment. In the case that you succeed with the reservation will be more, those vacancies which remain, you can put that only by a reserve category.
I'll put it this way, just as an interim. Assuming there are 100 vacancies, 56 is going to be, the 6 is going to be extra. So we'll go, subject to what you're looking, we'll go ahead with 56%. We'll not fill up the 6.
The only way we will say is don't issue a notification for your
56.
Out of 100, issue only for 93.
90.
Only issue for 93, follow 50% reservation which you already have, pre-challenge and continue and get persons on. Your vacancies of 7 will remain.
Please.
You pass in, because if you succeed, And that vacancies you fill up all by reserve category.
Actually, this would be a better thing because now again issue of fresh notification. Go through the
problem there. You put up 100 with seven reserve.
I'm sorry.
With 7% bonus. The issue is 7%. Now the persons who are coming in for this will have to then get through the rigmarole of the entire recruitment process.
Please.
So far, we are concerned, we are always ready for it. They cannot ask you for time because we are ready. At the time of granting
We are also ready. The question is the Supreme Court is hearing a transfer petition and they said that the first petition will be heard will be Madhya Pradesh. And Karnataka's transfer petition is also pending there.
No, not Madhya Pradesh.
Karnataka. What about the TP and the others?
Madhya Pradesh.
Oh, that is still pending.
There's several TPs.
Not Karnataka. Because the only thing is the question we don't want it to be transferred. We are happy here. No, it's not.
We'll defer it for one.
One more submission.
In fact,
just clarify that so that
any person, some organization which you have interdicted recruitment from, you will have to pass the order otherwise. You can't hold back the whole state.
I understand. Should we just observe that text so that
yes, they have not interdicted. They have not interdicted you from carrying on recruitment on the basis of the reservation of 50% as it exists. We have only said on the enhanced reservation you will not issue any notification. Issue notification on the earlier that we will clarify. After that, you can make an instrument, at least it is in your hand.
It's subject to we'll issue what specifically is mentioned in the notification, Malad. So far as this 6% is concerned, we should go ahead with this 6%, we will not go ahead with the recruitment. We'll go ahead with the test, everything.
But all process is on that basis.
We are notifying so many vacancies, not taking into enhanced, not taking the enhanced reservation.
No recruitment will be done for this 6%. Either this way.
Vacancies are kept open to be filled up and subject to the order of the court.
Please, Your Worship, may I observe that so that at least that we can go ahead.
That's what we are saying. You give a statement. We'll put it. It's not the direction of the court, but we'll accept that. If you say that you will take out a notification on 93% of the vacancies.
Not 93, 100%, but not 100% of the vacancies, but not go ahead with that balance.
Who will participate in the question? Your participation will only be on three positions. But to reserve your right, and subsequently you may just add reserve person. You can put a note there. That'd be
Instruction, if you watch this, I will come back on that.
One small clarification. Insofar as case recruitment is concerned, while setting aside the notification calling for application, has found out one more defect in the notification for the reason because once the act is issued, there is a rule 6 under the notification which says for that you have to frame rules, even assuming that by an act you can increase the reservation. To implement that reservation under section 6 of the act, you have to frame rules. Instead of without framing the rules, proceed to notification. The tribunal said without framing the rules, how could you notify? That is one of the defect pointed out. That's why they said issue fresh notification. Otherwise, if it is allowed to make recruitment in this manner, that is hit by their own rules, which says
for the notification that had already been issued and process was already underway. We are protected by saying that whoever gets in will ultimately, his appointment is subject to what the orders will be passed. The second question is what happens to the ongoing recruitment process. Ongoing recruitment process will take time and find out what to do.
But for that, they should not proceed on the basis of the new government order which has come into force. If they proceed on that, even every stage calling.
So it's like interim order, that's what clarification. We can't stop the state recruitment.
I understand. Only, as your officers were supposed to point out, is whether 50 or 56 is a short point.
Don't compel us now issue a mandamus for recruitment on. So any organization will have to give a direction to how to recruit, and that.
And in fact, our intention is also to go ahead with the recruitment. In fact, annexure 3, page 11, 12, 13.
You work out where your rights are protected, where this is protected. But the recruitment can't happen that you will.
I understand.
You protect at a later stage, issue an appropriate instrument to do it. If you succeed in this enhancement, we'll give you appropriate orders. Please. This is the 11th AG points out that several transfer petitions have been filed before the Supreme Court, as the issue involved in the present petition is assimilation. On. Say be listed before the appropriate bench in the month of January 2026. Submit in view of the above of present condition, we await the outcome of the decision of the Supreme Court. And so far as further interim arrangement is concerned, the AG seeks time to take instructions. Do an appropriate application if necessary. List on, put it next. Must put it in 3 weeks' time. But all of these issues have breached 50%. All of these states, because
all the states have breached 50%.
All of these.
Madhya Pradesh, Chhattisgarh, Tamil Nadu, Tamil Nadu,
Telangana.
Tamil Nadu anyway breached
long time back. I mean, they put it under the night schedule also. The question is whether just because you put under night schedule, whether judicial review is also the question which is pending before the Supreme Court.
But I thought that was decided. That issue was being decided. Huh? I thought that was decided when RDB and all those acts were put there. Surfacing and those acts were.
In fact, I think Manoj, they have referred once again, subject to correction, Manoj, saying that vis-a-vis reservation itself, insofar as Tamil Nadu is concerned, just because it's under 9th schedule, that is under challenge. In particular, with regard to reservation. In fact, your lordship's first query, Manoj, I should confess there is some difficulty. With regard to 338B, Manoj. Consultation.
That's right.
Then
if you recollect, it was your argument when we examined it in that
only
matter which we are examining it.
Post facto consultation is what?
No, the amendment for the backward classes, the 102nd and 105th.
Fifth amendment.
102nd and 105th amendment to the Constitution. The debate essentially says how the consultation should take place.
That is the paragraph 74 of the
G.Y.G. Rao.
Please,
the Supreme Court and G.Y.G. Rao. That's the Maharashtra matter, which was
correct.
Justice Bhatt's judgment.
Maratha reservation.
Justice Bhatt's judgment, which affirms 102nd Constitution amendment.
Please, absolutely.
That's the one where
the short point, as a lordship point, that's what I mean. Because insofar as the reservation, the appropriate, whether they have been
subject shifts from state to center.
Correct.
That seems to be the prima facie view.
What the Supreme Court has said, consultation on 338B need not be concurrent. As long as you have placed your information material is there, your competent.
The primacy moves. The primacy in SCST moves.
No, that's why what they say is,
subject to what submission is. The memory recall that 102, one of the grounds on which, after holding 102, second constitution amendment, the reasoning is now that the states will go and shifts to center in the backward class.
I'll just again verify.
The challenge in the Supreme Court was on the
102nd one, not second.
That was nothing to do with SC and ST, but to do with it. Maybe that was 338B that was
correct
introduced. There, while discussing 338B, the simile is put that, like in Scheduled Caste and Scheduled Tribes Commission, it is the power out there of consultation shifts there. Therefore, the state will have no power under or the state's role is somewhat diminished when it comes to backward classes in 338B. That 338B then goes.
The language for backward class, scheduled caste, scheduled is identical.
In 102nd.
102nd.
Therefore, when
subclause 9 was added, my lords.
Subclause 9 is in every case.
Every case.
Subclause 9 is deleted.
Deleted.
Effectively deleted in 105th amendment. But when 102nd amendment was in challenge, the reasoning seems to be that this is how you should follow, as you would follow an SC/ST.
Yes.
So if you follow that in SC/ST, you have an issue.
There are the only slight difference what I would make here, my lords. The consultation which has been referred there, it is not concurrence in that sense, but you have to consult whether it is mandatory or not is the question.
So in SC/ST is A and B.
Please, my lord.
Provision comes over. For backward classes comes provision C. On how C is worked out, the court says
same will apply to A and B.
Court says this is how it will apply to A and B. This is how it applies to A and B, and this is how it will work here. Now, if you apply that
ratio
to A and B today, of how it's worked, then you may have some issue.
That's the only issue. As your lordship, that's the only issue which will
one of the issues.
I'll have to.
One of the issues.
Only other thing your lordship may consider also, my lords, with regard to post facto consultation and the recommendation of the SC/ST Commission insofar as increasing to.
That may not be possible. That may
not
not
be. Your lordship will consider. That's what I'm.
No. Consider. Of course, you can. But I'm saying one of the contentions that we'll have to examine.
Shall consult.
Yes. Is
the language uses.
No. Also, how the process begins. If the process can't be reverted back, it's the whole issue. But we'll examine it. But we thought we'll start examining it from today onward.
Yeah, happy with.
12th of February.
12th February. Please.
I was telling my brother we have now one interesting matter.
In fact, there are two other as I said, validity of GB and ground rent. Those are also slightly.
Still number 27.
I have the endorsement. I'll pass it on. It is deposited before this honorable court, my lords. 2 crore odd rupees, please, is deposited.
No, my lord.
2024.